And hello, everyone, and welcome to the Copyright 2.0 show, episode number 378. As usual, I am Jonathan Bailey from the website Plagiarism Today, which can be found at plagiarismtoday.com. And joining me, also as usual, trademark attorney Evan Sherez, who I would like to remind everyone, though he is here to impart wonderful wisdom upon all of us, is not dispensing any legal advice today. If you want legal advice from him, and you definitely should, you should pay him. That's simple.
Thanks for that, John. Although I do have to mention that I do dabble, of course, in copyright law. Otherwise, what would I be doing here?
Indeed, indeed, indeed. Good point,
And,
good point, valid point.
You know, with my current job, I do a little bit of everything working in-house.
That's true, yeah. You're in-house counsel now. And that has got to be... I've always had a lot of respect for in-house counsel attorneys because you don't get the option of specializing. You have to deal with whatever comes your way.
Right. Today was a non-disclosure agreement with a client of ours. I should probably say no more.
Yeah, you dealt with a non-disclosure agreement, dumbass.
Yeah.
You said too much already.
I've said too much already. The first rule about non-disclosure agreements is don't talk about it.
No one talks about non-disclosure agreements. Yes.
Okay.
It's the Fight Club of the legal world.
It is the Fight Club of the legal world. You know what? That's a trademark that we should launch. We should launch our own brand of non-disclosure agreements with that, and I think we'll go places.
We'll go places. Yeah, all the way to I don't know who owns the right to Fight Club, but I'm pretty sure they would be exactly where we're going. Oh man, it's good to hear from you again.
It's good to hear from you too. It's been a little while.
Yes.
We both had
illness,
tough work schedules, illness, etc.
And that's one of the things I want to mention real quickly as a programming note. Evan and I talked about this. We're going to continue doing these podcasts because we like doing it. We're crazy. We're enjoying this, but our schedules do not enable us to guarantee a weekly podcast.
Right.
It's just not practical. So what we're going to do is I'm going to do a weekly short video series on YouTube. That's what I was actually working on before we got onto the show. And those will go live Fridays starting next week. But we will continue to do these.
The podcast will be a la carte.
Exactly. No set schedule, but we're going to shoot for every couple of weeks or so. I definitely want to keep recording. I love chatting with Evan. I love his insight. And I want to learn everything he is willing to impart. So, but yeah, we're both traveling a lot lately. I was at HauntCon. You were, Vegas, I believe you mentioned at one point.
I was in Vegas last week for about a week.
Wow. You know, it's weird. Vegas is such a big conference town, and I've never been.
Really?
I've been to I was actually trying to do the math on this last week. I think I've done 50 conferences, none in Vegas.
It's a little bit of a dangerous spot to go to for conferences, of course, because there's so much partying.
Well, New Orleans is the same way. I mean,
obviously, I did not take part in.
Obviously not. No. Evan would not dare.
They have a convention center called the World Market Center, which is dedicated to the import/furniture industry. So That's where we went. It was a great time. The show was interesting. I met, some interesting people, and yeah, it was good. But I don't want to, dilly-dally here any longer.
No.
Why don't we jump into the stories that we're going to be talking about today?
Before we jump into copiers, any trademark news you care to impart? I know we were trying to touch base with the trademark world every once in a while. Any interesting trademark news? I've not heard of any, so if you have some, it would be brand new to me.
Nothing on my radar right now that I would feel comfortable talking about.
Fair enough. So, yeah, we've got a lot of copyright news to go through today. Back-to-back Supreme Court news. One, the Supreme Court is giving a repeat performance in a case.
Mm-hmm.
And then one where they are being asked to give a performance in a case. Then we have what seems like should have been inevitable. We have a photographer suing artist Richard Prince. And then we have a very interesting case dealing with import-export stuff, as Warner Brothers is suing a 4K content protection stripper, as not that kind of stripper, a different kind of stripper. Also, update on the monkey selfie case that I'm sure has Evan breathing a sigh of relief. The New Girl case was tossed, and the Beastie Boys have reached a settlement with Monster Beverage, I believe is the company name. And when to wrap things up, we take a look back at MP3 Tunes and the continuing saga of trying to get any money from that case. And finally, one of the great hypothetical scenarios in copyright comes back again as we get to talk about another tattoo case.
Yeah, a lot of really interesting stories, and let's jump right into Kurtzang.
Yes, the SCOTUS here taking up Kurtzang again. And now, this is the famous textbook case that literally is a case about textbook. I'm not saying it's a textbook case, because if it were a textbook case, it would only make one trip to the Supreme Court.
Yeah, the story behind this case is that a gentleman by the name of Supap Kurtzang built himself a business on eBay buying textbooks out of Asia in English and reselling them to students in the US.
At a much, much lower rate.
Right, because of the giant markups on textbooks here in the US. John Wiley and Sons, a publisher, brought a copyright lawsuit basically saying that, hey, we have the right to control imports into the United States, therefore you should not be able to do this. Now, this case went through the gauntlet, went all the way to the Supreme Court, and it centered around a concept called the first sale doctrine. Copyright owners, as most of you probably know, own the right to the distribution of their works. It's one of their 6 exclusive rights. So technically, when you sell your book that you own, you're violating that right. Now, even though you're violating that right, it's not a copyright infringement because of the statutory defense in the Copyright Act called the first sale doctrine, which says that, yeah, even though copyright owners have the right to the distribution of their works, you, as someone who has purchased one of their works, have the right to resell that individual work, and we will protect you from infringement liability.
And this is why used bookstores, used CD stores, etc. are a thing.
Right. So no one had really looked at the first sale doctrine in the context of the importation rate.
Yeah.
So there was the question of whether it protected Kurtzang, because all he was doing was buying individual copies, importing those, and then selling them. No one had really looked at whether that first sale doctrine protected him against the importation right, and as it turns out, it did. And he won the case. And
that's a very, very interesting. And if you think about it, it seems kind of bizarre because, well, we kind of take for granted the idea that you have the right to resell something you legitimately purchased. You buy, that CD, you can then turn it into a CD store and get 50 cents, back for the whole thing.
Right. If this was 1993 or something.
Yeah, well, or a better example for, I guess, 2016 is the GameStop example. It's why there's a used market there, and you can take your Xbox games back and get $20 for a stack of 10 games, and then cry about the resale prices.
Right.
Yay. But the point is, it was not really thought of that intensely because these types of first sale transactions rarely involve the importation of something.
Right. It was one of those things that you just couldn't predict would require statutory clarity. Who was buying something abroad and then paying to import it back in and then still being able to make a profit? It just wasn't on the radar at the time of the...
Which is something that actually... comes up in Australia because you keep reading about how like Adobe Photoshop, it's cheaper to get an airplane ticket to the United States, go and buy Photoshop here and then bring it back than it is to buy it in Australia.
Right, and in the same vein is that company that is selling airline tickets by allowing the purchaser to take the first leg.
Skip leg, yeah.
First leg of what is a connecting flight. It's just one of these little gray areas built into what is essentially large margins.
Yeah.
And so, anyways, moving on to the case here.
Yeah. Kurtzang won.
Kurtzang won.
That's the main thing we need to know. Kurtzang won.
Kurtzang won. And he was denied attorney's fees.
Which means that victory's kind of moot in a weird way.
It can be
victory.
When you go through 3 levels of the court, it's unlikely that your case was large enough from a financial perspective.
Especially since he was just a dude selling textbooks.
Right, to really pay off. So The Copyright Act allows a judge to award reasonable attorney's fees for the prevailing party, basically at their discretion. Now, this certiorari is filed, and really it took advantage of an area of the law that often gets the Supreme Court's attention, which is that there's a circuit split. So anytime there is a significant circuit split, the Supreme Court is more likely to step in. Now, had Kurtzang prevailed in his opinion in the 9th or 11th Circuit, he's of the opinion that he would have obtained his reasonable attorney's fees. Had he prevailed in the 5th or 7th Circuit, he would have had a rebuttable presumption in favor of obtaining his attorney's fees. And had he prevailed in the 3rd, 4th, or 6th Circuits, Kurtzang very likely would have obtained his attorney's fees just because the standard was different. In the 2nd Circuit, the standard for the judicially created standards, because again, if you look back at the statute, it's really at the discretion of the judge, so that kind of leaves room for judge-made law. In the 2nd Circuit, where this case was filed, the losing party suit, which in this case would have been the publisher, must have been objectively unreasonable. So if you look at the difference between the losing party suit being objectively unreasonable and the rebuttable presumption of prevailing attorney's fees, that's a huge gap. It's a huge gap.
Yeah.
And that standard of objective, the losing party suit being objectively unreasonable isn't used in many other circuits. And so it's the perfect candidate for the granting of certiorari, which is what occurred.
Yes.
You know, my personal editorial view on this is that I think the court is ready to give us a uniform standard on this issue. I think we're going to see the Supreme Court come with a universal standard, but I don't think that Kurtzang is going to get his attorney's fees, because I think that Wiley brought a legitimate claim. This was a legitimately confusing and a legitimately triable issue of the law.
And the fact it made it before the Supreme Court proves that, I think.
I think so.
Plays, at least favors that argument strongly.
You know, there's 2 different issues that'll get there. Or maybe 3 different ones. There's political issues that the court just wants to take up. There's issues which are so wrong that the court just feels the need to correct it. And then there's, you know, this 3rd area of cases that are legitimately
in dispute. Yeah.
In dispute. And you know, of course, there's always the overarching factor of circuit split, which I had mentioned. But that leaves us with a very interesting case that I'm sure we're going to revisit when the time comes. And I think that's really all my thoughts on this case. Unless you got something to add, we can move on.
I think I want to go on record saying I agree with you. I don't think he's going to get his attorney's fees, just because there was nothing in what Wiley did that was in any way, shape, or form crazy. I mean, they were not out of line at any point. They made solid arguments. They had a very, very good case. It's just the law at the end of the day did not favor them. And that happens. There's nothing they could have done differently.
Right.
I think you're right. And this is one of the reasons why a lot of these cases don't happen, is because the cost of fighting it out is way higher than the amount that can stand to be gained.
Yeah, so there's really a lot at stake depending on what the Supreme Court comes out with here in terms of a uniform standard. It could either, you know, put a chilling effect on copyright litigation, which may not be a bad thing depending on your perspective, or it could significantly increase it, which I doubt. I don't think that the Supreme Court wants to encourage the granting of attorney's fees in most cases. That's just my instinct on the matter, though. And ultimately, what they end up deciding, if they do impose a standard, which they are likely to do, it will have a large effect one way or the other. Now, that brings us to, I think, the second most interesting cases. We're getting the really good ones out of the way. Which is
the ones that the Supreme Court may either has agreed or will be maybe looking at. So,
it is my opinion that there's zero chance that the court will look at this case.
Okay, fair enough.
But why don't you tell the listeners, or remind them, because I think we've talked about it a few times, about The Batmobile case.
Yeah, and then the long and short of this case is that there was a garage in Temecula, California. I have no idea how to pronounce that. Owned by a gentleman named Mark Towley, who basically made reproductions of Batmobiles, specifically the 1960s Batmobile, the iconic twin-seater with the open top. It can basically the one you wouldn't drive in the rain, and the 1989 Tim Burton film Batmobile, which I thought was still goes on record as probably my favorite Batmobile. That thing is badass looking. He was sued by Warner Brothers, alleging copyright infringement. He argued that, hey, this is just, a functional item. It's a useful article. It is not protectable by copyright. Warner Brothers countered by arguing that these are not just functional articles. These are essentially characters in the Batman universe. And, well, long story short, so far as Talley has had no luck at either the district or the appeals court level. The Ninth Circuit shot him down pretty hardcore. So he has now petitioned with a writ asking the Supreme Court to look at this case, and specifically 3 questions he is wanting to look at, and I'll just read them off real fast. Whether a court may judicially create a subject of a copyright that was specifically and expressly excluded by Congress. As such, when Congress enacted the Copyright Act, thus circumventing the clear mandate of Congress and the U.S. Copyright Office.
Let me jump in there. These are all complicated questions, and
please do.
I feel like if we go through the 3 questions and then
come back.
The first one was.
I agree.
So I don't. This is such a loaded way to.
It is. It's like the most leading of the leading questions.
It is so leading. By asking the question, they're basically just saying that, hey, what about useful articles and the fact that this is a category, aka cars, that shouldn't be under the purview of copyright.
It's almost like asking, is the court able to be a stinky poo-poo head? Or,
Thank you for both of those distinct legal arguments. When you were saying that they got a hardcore beatdown, and then that one. So this isn't a fair way of bringing up the question that, hey, there's this concept called useful articles, and a car is a useful article, therefore the Batmobile should be afforded no protection, when the reality is that in no way, shape, or form did this court say that cars are copyrightable. What they said was that the Batmobile as a character has elements that are separable enough from the useful article parts of the car, aka the way it looks, and
those rocking fins on the back, and
stuff that are not useful by nature.
Yeah. If you've looked at the 1989 Batmobile, there ain't much useful article about.
The issue here can really be tied in with the third question, which is whether a determination of substantial similarity of protected expression must be made in a copyright case. Those 2 issues together, I think, is their fair point, which is that the court, in determining that the Batmobile was copyrightable, basically didn't parse out some of the elements that may not have been separable, because parts of the Batmobile are, for example, its jet engines and its ejector seat, all this other stuff that kind of makes it what it is. Well, some of those things are useful articles that maybe shouldn't be subject to copyright, especially in the context of, I'm making this actual car, not that the car that he made had jet engines or an ejector seat, but the court should have separated some of the more pragmatic and more useful elements of the Batmobile and saying, okay, these attributes are not copyrightable because they are useful articles. But the rest of this stuff together still allows the Batmobile to retain its status as a character. And that's, I think, their real protest in saying that the court should have done that, because the fact that it didn't do it kind of leaves us in this area of, wait, you never really gave our argument that separate from those that if you separate those useful article elements, there isn't enough for character here. And so I feel like that's their legitimate gripe.
Yeah. But you believe there's still no chance
that the court will take it? No, I don't
Yeah.
think so. The court took its copyright case, and there's really, when you compare it to attorney's fees across the country being the question here, I'm not sure that, the characterability, I don't know if that's a word, or the ability for an inanimate object to be a character, although cool, in my opinion, is really of a pressing nature for the Supreme Court.
I would agree. It probably is not. But it is an interesting question nonetheless.
Right, which is the second question that we glossed over, which is whether an automobile that does not display any personality traits or any consistent and widely identifiable physical attributes can be protected by copyright as a character. This is basically asking in general, like, hey, doesn't a character have to be a character? Isn't that the case? Which is a great question, because is the Batcave protectable? Maybe it is, since it has so many.
What about the Batarang or other stuff he has?
Exactly. So
that was a character, not as.
What is the definition of a character? Which I think is a fantastic academic exercise.
Yeah. And it's also it's one of those areas of copyright law that is interesting, not just because of the copyright questions, but because it raises philosophical ones too. Like, when does an item become a character? When does a person become, when do you go from being a person to being a character? What makes someone or something copyrightable? I
always thought that there had to be some sort of personification, right?
Yeah.
Which is, where human qualities are given to an animal object or an idea. So Charlotte from Charlotte's Web is a character, even though, that's fine. A spider, an animal, can be a character. But if Charlotte from Charlotte's Web was a stapler,
So you would agree.
I think that would be okay too.
Yeah, but you would agree, like Kit from Knight Rider is a character.
That's the perfect example. But it is a very slippery slope, in my opinion, when items which are not personified, but are merely items with distinguishable characteristics, are then given copyright protection as characters. Now, there's lots of other ways that that things with unique appearances can be protected under copyright, like the Batmobile.
Absolutely.
But as a character, that is a specifically delineated area in the law, which I'm not convinced is applicable to inanimate objects.
I agree with that. And because one of the things I would argue about the Batmobile is, you could say, well, okay, yes, it is a useful article, but it's also a decorative sculpture too.
Agreed.
You can make arguments such as that, because, you can make a car that doesn't look anything like the Batmobile. The useful article element and the decorative elements are very separable, and in my opinion. But at the same time, pushing it to making it a character, that kind of doesn't sit right with me either. There's plenty of things that are protected under copyright that are not characters, basically, like nearly everything. But alas. All right, well, shifting gears to talking about artist Richard Prince and his controversial New Portraits exhibit at the Gagosian. We have a lawsuit, and this should really surprise nearly no one.
Yeah, this is our simple theft, not even close case of the day.
Yeah.
We've talked about this, I'll be kind and call him a gentleman, before. It's the outright theft of someone's photographs, not even close to having enough change to be considered transformative under the fair use doctrine. And not, in addition to all that, it's an outright admission of theft by the defendant, who went on Twitter to rant about how when he was poor, no one cared that he stole things. And now that he's rich and successful, he's being sued for stealing. What a tragedy, right?
Yeah, I know, how horrible. First world problems taken to the extreme. The thing about Richard Prince is he is, of course, very famous for the appellate court ruling, which went in his favor when he took images of Rastafarians and so forth and added like guitars and other elements to them. The photographer sued, and largely it was a defeat. Not a complete one, but it was a large, on the whole of the feet for the photographer. But here, he's come out, and this is basically just, he's taken photos from Instagram and reprinted them and added his comments below. He's not transformed the images in any way, other than cropping them, maybe, in some cases.
Right, that's what happened in this case. The image at question, which if you are following me on Twitter, I will tweet out right now, is of a Rastafarian lighting up.
Yeah. And the original work, I mean, Prince obviously cropped it, but other than that,
it's just a crop.
It's just a crop. There's no change. It's the photo, and it's blown up to very, very high proportions, very, very large proportions, so it hangs on a wall. And he added, you know, Instagram-like comments below.
Right.
And that's it. That is what it was.
So right, I just tweeted out the image. It was apparently taken by someone else on Instagram, and then he stole it from that person. And so we have a suit here, and I hope that Richard Prince is financially punished.
Yeah, and the photographer, by the way, from the earlier case was Patrick Carew. I think it's Carew is how you say it. I don't honestly know, but yeah. So yeah.
In this case, it's renowned photographer Donald Graham. I can't say I'm tuned into the photography.
No, me neither.
Well, I'd like to be.
I am reasonably sure he is extremely famous and all that. I just don't know that world and don't know him.
Right.
So yeah, but this is such a clear-cut case. I don't see much of a challenge proving it here, and this is just, I think, Prince pushing it way too far.
Right, I agree.
He was emboldened by his 2009 victory, and now I think he's pushed it beyond any reasonable standard.
I agree, and I think that just brings us to talking about strippers.
Yeah, strippers. 4K strippers even. Yeah. Yeah.
Yes, 4,000 strippers. No. What we're going to be talking about is Warner Brothers and Intel suing 4K content protection stripper, which essentially is a program which is designed to bypass some of the protections that 4K broadcasts are being used to protect 4K broadcasts. That did not come out correctly. I'm going to leave it to you, John.
Yeah, long story short, whenever they created the standard for 4K video, they introduced a sort of a DRM standard to encrypt it so that you couldn't just simply, you know, purchase the content or the stream or whatever, and then immediately take it and move it, you know, to file sharing sites. In fact, there's a company involved that actually produces, I believe it's one of those companies that sort of is a cooperative effort among content creators. It's called the Digital Content Protection, DCP is the company. Digital Content Protection is the company, which has got to be the least creative name I can think of. Yeah, and it's a sister company of Warner Brothers and Intel. Long and short of it is a Chinese company released what is called an HD Fury. It is a physical box which you are basically able to insert into put it between two devices that are one that's broadcasting the 4K video and one that's receiving it, and it can strip away that DRM and then enable you to copy and access the stream on other devices than what you should be able to. And the long and short of it is Warner Brothers and DCP have filed a lawsuit against this company. The company's name is Legend Sky, claiming that they are violating the DMCA's anti-circumvention provisions, which basically prohibits companies from manufacturing and selling products that enable people to circumvent any content protection scheme or digital rights management scheme, DRM.
Right. This is one of the lesser-known areas of copyright legislation in general. I think if you talk to most people, they would have no idea that this is the kind of thing that comes along with your general protection and rights and grant of rights. Is this part of the DMCA, which says that don't hack us? That's basically what it says, you know, for the layperson out there. And I'm glad that you were the one to explain the rest of that, because you've got a better grasp on some of the more technical issues.
Yeah, and it's very interesting because this company is importing them into the United States. These, to my knowledge, are not manufactured in in the U.S., but due to the fact they are being imported, that gives the standing for the lawsuit, at least in theory. Now, what Warner is alleging is that there's like, if you go to like the Pirate Bay and all these other sites, there were no 4K, files for download. That'd be insanely expensive from a bandwidth perspective. I can imagine this would be huge video files, but there was just nothing there. This product is released, and within a few days, mysteriously, you can find pirated content in 4K. Now, I don't believe in coincidences personally, but this seems to be a pretty striking one.
Agreed.
So yeah, it's a pretty solid case, I think, on Warner's part. But the question is, what good is it really going to do? And the answer is probably not a whole hell of a lot. The product's out there, it's already been purchased, and yeah, they might be able to stop future imports of it, but if this technology is already so easily broken, it's only a matter of time until someone else manufactures a similar device.
I think that's the trend with almost every anti-circumvention lawsuit that's taken place.
Which is why I've been very fascinated by the unbreakable DRM and what they're calling the unbreakable DRM for video games. Been going around.
That's the first time hearing about
it. Hang on a second. I'm trying to pull up the name of it. I was reading about it. I didn't put it in the show notes because long and short of it is there's still a lot of uncertainty about just how difficult it is. But there's a DRM entitled, come on, it's right here in the show notes. I've got an article up about it. It's called Denuvo, DENUVO is the solution. Basically, it was applied to Just Cause 3. I'm sure you've heard about Just Cause 3, the video game. That game was released December 1st. As of this video chat, which is taking place on February the 5th, 2016, so well over 2 months later, no cracked version of it is available on file sharing sites.
That's very impressive.
That's more than 8 weeks delay, and that is, impossible. Now, they said they have cracked Denuvo before, other versions of it, but it took over 9 months to do.
That's good news, I guess, for anyone seeking to protect some, their video games, and most of the time I hear, or if my friends were looking for a cracked version or something like that, I remember it being quite swift.
Yeah, it usually is quite swift, and then because of this success, the new games like the new Tomb Raider game are also being released with it. Its use is being highly expanded. And one guy, apparently, one of the head cracking groups based out of China, EOM is the group, has said that he expects video game DRM to become completely uncrackable by 2018.
Wow.
Now, I don't know how hyperbolic that is, but it's an interesting statement to say the least. So yeah, Denuvo apparently is at least extremely crack resistant. But I guess I still believe the cat and mouse game will continue for the foreseeable future. It's just right now the cat, or is it the mouse? I'm not sure who's who in this relationship. But the video game, the DRM has the upper hand in video games for the moment.
For the moment.
For the moment.
All right, well.
Monkey selfie time.
Monkey selfie time.
It's finally, basically the monkey selfie case has finally been dismissed. Now, we talked about this great detail, and you placed your very interesting wager on it.
I placed multiple wagers. Yes, my bar license. I said I would streak through the streets of D.C. And a bunch of other things if this monkey was granted.
Well, the ladies of D.C. are disappointed today because the lawsuit was dismissed. Yes. Now, what's in the background of this case is that there was a monkey, a macaw monkey named Naratu, that took a camera from a photographer and snapped a very, very cool selfie with it.
Yes.
Creating a copyright crisis, if you will.
The world was waiting with bated breath.
Because
such a big...
Yeah, especially you. Because the question was, who holds the copyright in this photograph? Is it the original photographer? Is it the monkey? If it is the monkey, then can a monkey even hold a copyright? and a million other interesting questions. And to help answer those questions, and I'm using help in the loosest way I can, People for the Ethical Treatment of Animals stepped in and filed a lawsuit on behalf of the monkey to basically gain control of the photograph, and in PETA's view, license it and then use the money to aid the monkey.
Yes, last year, shortly afterwards, the U.S. Copyright Office issued an updated compendium of its policies, including a section which stipulated that, we're only going to register copyrights for humans.
Yeah, no monkey copyrights, no animal copyrights at all.
No.
And you realize at this point, and you and I know, the U.S. Copyright Office is like way overtaxed. They don't have the resources they need. They don't have the people they need. They're really struggling to do what they can with what they have. And some idiot has to sit there and explain why animals can't hold copyright.
Yeah, well, hopefully no longer, since this court in California has done the same thing and said that there's nothing in the Copyright Act which says that non-humans can receive a copyright in an artistic work. Which is, of course, not to say that animals don't have certain rights under the law. There are animal cruelty rights which protect them, etc.
Yeah.
And that's just where it ends, though.
One thing that was pointed out, and this is something that I've been having a lot of fun with on Facebook, is pointing out that this case was dismissed without prejudice, which means the monkey can refile.
The monkey can return. Well, that's interesting because usually a case is dismissed with prejudice if there's really nothing that you could do to correct it.
Yeah, and
so
that I found interesting. So at least theoretically, the judge seemed kind of, I want to say the word is bemused by the argument.
You couldn't come up with something better than that? Just off the top of my head.
Okay.
There's no good puns. I for sure thought you were going to come up with a good monkey pun.
Well, he wasn't flinging poo at the arguments. I mean, he was.
Oh God.
He was just. Basically, he seemed, the judge in the dismissal seemed intrigued by it.
Right.
And even though he didn't really think there was an argument that could work, he filed it without prejudice, kind of, I guess, on the hope that they would come up with a more novel argument. But yeah, I don't see how they're going to get around the issue of A, monkeys can't hold copyright, and B, monkeys can't really have standing either.
Right.
Because the law pretty expressly states that animals cannot have standing in a court in California. The law pretty much expressly states that animals cannot have standing unless the law expressly says they can.
Yeah, I'm surprised that he wants to monkey around with this lawsuit any longer and didn't just dismiss it with prejudice.
I would have dismissed it with prejudice too, but it was dismissed without prejudice. And so there is at least a theory that the monkey could return. But that has led to my new hipster band name, Selfie Monkey Hope. So if ever I do form one of those hipster bands, like the Neutral Milk Hotel type things, where you have to have three words that have no meaning together, it will be the Selfie Monkey Hope will be my hipster band name.
All right. Thank you for enlightening us with that.
Okay.
I did actually wonder what you would do with a hipster.
Yeah, I know. It's going to happen. There's a very real danger I could have a hipster band at some point.
Okay.
New Girl. Zooey Deschanel.
I love Zooey Deschanel.
Everyone loves. How can you not love Zooey Deschanel?
How can you? I agree. How can you not love Zooey Deschanel?
She the subject of a copyright lawsuit of their own. At least they once was a copyright lawsuit.
Yep. So here, summary judgment was granted to the defendants, which is Fox and a number of their executives, in which the lawsuits regarding New Girl, which claimed that the idea was stolen from a script that the plaintiff submitted, it was quashed. So it was really a double blow here, because the judge basically ruled that, first of all, you're down on a crucial part of your case, which is that there was access. They could not prove access to this pilot script called Square One by the defendants. which is key, right? You need
Yeah.
substantial similarity and access to prove copying in a case. So there was really not enough proof on the record, which by the time summary judgment comes around, you need to have submitted evidence.
And you see that a lot with these types of cases where access is an issue because they can prove like theoretical access. Like, oh, I was distributing copies of it around the building at the 11 p.m. one day, or what, you know what I mean?
Right. It's not that hard. Those things can work.
Yeah.
But
they couldn't even get that far.
They couldn't get that. They couldn't show the link that the script was in the hands of the defendants.
No.
And beyond that, which is damning enough, you basically had the judge saying that I've looked at your script, and I don't think that any reasonable juror could come to the conclusion that the two plots shared a substantial similarity. And that's hard to do. With substantial similarity cases, they really do have to be significantly different for a judge to say that no reasonable juror can come to that conclusion. So this was the final blow, in my opinion, for this woman's case. And so Square One will unfortunately not result in this woman getting royalties for New Girl, which is a highly, highly successful television show.
Yeah, well, it's highly successful because Zooey Deschanel. There you go. Everyone loves Zooey Deschanel.
Right. This was odd timing because my dad was telling me, he's like, Evan, it's like I have a screenplay.
Oh no.
That I wrote, and which is ridiculous because my dad's your average business guy, and the notion that he was doing anything of the sort was a complete shock to me. He's like, yeah, it's about my grandfather, his father, who was a partisan fighter in Europe, very celebrated. There's been a few documentaries about him. And he's like, oh, I know somebody in LA who's this, and I'm going to send it to her. So he ends up sending to me, and by a screenplay, he means it's 4 pages. So he's like, yeah, that's what I meant. A screenplay. I'm like, no, that's not what a screenplay means.
That means more of a treatment, I think.
But more and more, he's like, well, can you make sure that I don't, get screwed? Yeah, get ripped off. And I was telling him, I was telling him about this case. I'm like, really? I can't do that. Unless you get this person to sign something, which the average cold-called person who is working in the business, when they get a call from someone who's not in the business, says, oh, I have a great screenplay, they're not interested in signing something with you just to get your idea. And so, if someone wanted to take my grandfather's story and put it into film, I'm pretty sure they can come up with enough changes to make it only inspired by a true story and not significantly.
I mean, it's different. I'm pretty sure you could show substantial similarity between Saving Private Ryan and Starship Troopers. Well, they're both war movies about rescuing someone.
Well, that's not substantial similarity.
Well, not substantial enough to get past the judge in the summary judgment phase.
I don't think so. I disagree.
Oh, come on.
No.
You're ruining my joke. I was trying to think of 2 movies that had 0 in common, but I can make an argument.
I've seen both of those films, and I don't think they're even close to.
They're not really. It's I'm intentionally stretching.
Okay.
But yeah, I'm quite deliberately stretching a lot. But yeah, speaking of stretching, Monster Energy drink has reached a settlement. Monster Beverage. I'm sorry, I keep saying Monster Energy drink, probably because I drink Monster Energy drink all the time, but it's made by Monster Beverage. Have settled their dispute with the Beastie Boys at long last.
Right, an odd timing for a settlement. There's been a $1.7 million jury verdict and an award of nearly $700,000 in legal fees on the topic of legal fees that we were discussing. And basically, there was an appeal ongoing, but the two parties have come together and decided that it was time. Yeah,
and the long and short of it is Monster used remixes of 3 Beastie Boys songs. Beastie Boys, a band very much against having their music used in commercials. Used it as part of an ad to promote an extreme sporting event they were sponsoring. the ad itself was like apparently this YouTube thing that didn't get a lot of traction, but nonetheless, it's still a copyright infringement. And Monster admitted as much, but they could not come to terms pre-trial over how much was owed.
Right.
And yeah, Monster got dinged pretty hard at trial. And
they did. It was a clear loser, you know, and there was I think as we've discussed before, when your product kills somebody, it's hard to argue against the ethical and brand impact, because I believe there was a number of trademark issues here as well.
Yeah,
they argued that there was some sort of implicit endorsement implied when they used their songs, and so they sued on a number of counts. And so when there are deaths due to the use of your product, which was all the rage at the time about whether energy drinks were healthy or not, etc., it's tough to really get away from getting your ass handed to you, for lack of a better word.
Yeah. Well, and you know, Monster really handled the whole thing quite terribly. They knew they had infringed. They admitted they had infringed. They admitted they made all these mistakes, and then tried to lowball on the settlement when they knew they had absolutely no high ground.
Not a great strategy.
Not a great strategy. You know who else should be watching this case? All the politicians right now who are getting caught using people's music that don't want to be, you know, associated with them. Because yeah, you know, your public performance licenses can cover the copyright angle, but there's still all kinds of other issues.
Well, I'm shocked that you didn't put the Mike Huckabee defense into the show notes.
I should have. You're right. We had so much to go through, and stuff just fell through the cracks. I got to be honest.
Yeah. So for those of you who don't know about Mike Huckabee, did he end his campaign? I believe he did it. He did end his campaign. The former presidential candidate who tried to get some momentum off the Kim Davis mockery of
that old mess.
Fact that religion and government should be separated. He played Rocky's "I Will Survive" in parading her out after she got out of jail.
"I Have the Tiger" by Survivor.
Right, "I Have the Tiger."
Yeah. "I Will Survive" is a very different song.
It is a very different song. I don't know what made me think of that song, but I will survive. I Have the Tiger, and they got sued, and he's somehow arguing that it was a First Amendment practice of religion defense to a copyright infringement. It's wild. It makes no sense.
Yeah, and Batcave was researching that issue a little bit today, because a company subscribed to a newsletter called the Christian Copyright Solutions, and they provide music licensing assistance to churches. And they note quite correctly that there is a religious services exemption to the public performance clause, but that is limited to just the actual service.
Right.
You know, if you use it as part of like a book sale or, you know, a concert or anything else you do at a church, you need that public performance right to pay those royalties.
Right. So to be exact, it's a religious assembly defense.
Yeah, exactly. It's a religious assembly. Anything that's not related directly to that religious assembly, that act of worship, does not have that exemption.
Okay.
And that's a huge stretch, because if a church has to get, you know, permission or a license to have a concert outside, you know, and as part, not part of the actual worship services, then I can't imagine Mike Huckabee making that argument work that a Kim Davis political rally is, you know what I mean?
I agree with you. You know, this is actually an area that I'm not too familiar with, but
yeah,
very, very intrigued by the prospect of we're looking at the case law as to what has been traditionally defined as a religious assembly, because it is kind of a broad term. If I'm just thinking about it, but I don't think that could in any way, shape, or form be considered a religious assembly. I mean, I saw it happen. It was a political rally.
It was very much a political rally, and they were holding it right outside the jail. And I'm reasonably sure the jail does not have its ASCAP and PMI and CSAC licenses.
I wonder if jails. I mean,
wait a minute. Now I wonder. Oh my God.
Maybe some of them do. You know, prisoners. If Orange of the New Black has taught me anything, is that prisoners have parties with music sometimes.
that this is true. Maybe they do. Oh my God. This could take on all new twist and turn. But then again, they weren't actually having it in the jail. It was near the jail. I don't think it covers like outside the jail, right off the jail property either. But
all right. Well,
man, how do we go down these rabbit holes? Now I'm wondering about music licensing in prisons.
I don't know. It happens every show, though. So
It happens every show at least once. We go down a rabbit hole we don't really recover from. Okay, MP3 Tunes. Let's change gears before we go too far.
Take it away.
Well, long story short, MP3 Tunes was a music sharing and downloading site that, as these sites are wont to do, got sued by the record labels. And in a very interesting twist in this case, the founder of the site, Michael Robertson, who is up there with John Smith for having the most generic name you can fathom, was actually found personally liable in addition to his company, which we call that piercing the corporate veil, and it's pretty difficult to do.
Right, it happens when the corporation is essentially a sham.
Yeah.
It's the principal is you, and the decisions, quote unquote, that the business was taking were really to benefit you and not the business. It's essentially a fraud protection.
Yeah. And he, as an individual, was ordered to hand over some $15.8 million. So not just piercing the corporate veil, piercing it with a very long sword. It went right up his, never mind. But
we're not going there.
We're not going there.
No.
Long and short of it, though, is now the record labels are saying that they've been unable to, even though this all took place in 2012, they've not been able to get any of the money from him. And
why is that, John?
Well, it appears, according to the record labels, that he separated and then divorced his wife, and mysteriously she wound up with all his assets.
When did that happen, John?
They began the separation proceedings right after he was added personally to the case.
Wow.
Weird.
What a coincidence.
I know. What a coinky-dink. I mean,
it's
very suspicious, isn't it?
Oh, so you're saying that maybe they initiated separation and divorce proceedings and transferred all his assets to her and multiple trusts, according to the reports, because he knew he was going to end up losing everything. And it's kind of easier to lose everything when you're already bankrupt.
Yes. Me losing everything is not that big of a deal. I didn't have that much to start with. But someone with multi-millions of dollars, multitudes of millions, yes, it's a little bit more heartbreaking, isn't it?
It's a little tougher.
A little tougher. So yes, that is exactly what the record labels are alleging, that this curiously timed separation and divorce was a sham to shield his assets from what at that time seemed like an almost inevitable judgment against him. I share the suspicion.
I share the suspicion. The wife is trying to use a number of legal tools to stop the subpoena.
And those legal tools are called lawyers. Hi-yo. No, wait.
That's not nice. Come on.
No, I'm sorry. You set it up, though. I couldn't help it.
A number of legal tools. Okay, that was a good one. I'll give it to you. But she's trying to allege, for example, that there's their marital communications privilege. To quash a number of parts of the subpoena, including they're trying to get her to testify, which is basically saying that a spouse, and this goes all the way back to the common law in England, cannot be forced to testify against their husband or wife for communications made while the marriage was occurring. Has something to do with that body being one person, and they wanted to encourage marriage. I'm not exactly sure the policy reasons behind it, but that's one of the things he's trying to use. But I don't think it's going to work here. No. The courts generally tend to find their way around legal defenses when they're motivated by a fraudulent transfer.
And that's one of the things I've learned years and years of watching court cases, copyright and other ones. Courts do not like it when people play games with them. That is the end of it.
It's the end of it. I agree.
They really do not. And you want to make a judge work harder than anyone else in the world. They will do backflips and somersaults and all kinds of other gymnastics to find a way to stop people from playing games with them. They become very, very, very dedicated to their job with that type of stuff. So don't screw around with that. Seriously.
Yeah, well, I think that the court will find a way to get the
yeah.
money away from the wife, and
Absolutely. And
it seems like these separation agreements were all meant to defraud the winners of the case against them from recovering.
because once he was added personally to it, once into that corporate veil was pierced, he knew that the judgment against him was practically inevitable. At that point, we were just waiting. And any move to transfer assets away from him is very suspect. So, and that's the way the court's going to look at it.
I agree.
I mean, basically, if I get a lawsuit against me today and I go, whoopsie, and I conveniently transfer everything I own to Crystal or someone else, that's going to look very bad.
Yeah, the court will find a way through that.
The court will find a way. Well, we're ending it on another one of life's great hypotheticals. We have talked about tattoos before on this podcast. I don't know if it was with you or if Patrick covered it, but man, I love this hypothetical question. Long and short of it is this: copyright protects works of creative expression once they are fixed into a tangible medium of expression. Now, normally we don't really care what it's fixed to, right?
We don't. And John, let me ask you, how's that skin on your face doing? Still there?
It's still there, yeah.
Relatively permanent?
Relatively permanent. Okay. It seems to be doing pretty good, holding up.
Okay, so go on.
Now, long and short of it, we don't think much about that because we don't care if it's paper, the hard drive of your computer, a mural on a wall, or whatever. But what happens when it's a tattoo and it's affixed to skin? Is that meet the criteria of a tangible medium of expression? Well, we may find out because Solid Oak Sketches, a tattoo parlor, has filed a lawsuit against Take-Two Interactive, alleging that Take-Two, when it created NBA 2K16, because these NBA early games had to get more obnoxious somehow with how they were named, NBA 2K16 reproduced the tattoos on NBA players such as LeBron James. And long and short of it is he's claiming their copyright over those tattoos.
Which, in theory, is perfectly reasonable. They have a creative expression fixed in a tangible means.
Yeah.
It was reproduced. So, if you look at it from that perspective, sure. But let's get classy here for a second, and we'll hopefully classy if I don't butcher this, but de minimis non curat lex. The law does not concern itself with trifles. Nobody cares that there's a little image on your television screen of that tattoo. If the court takes this seriously and grants them anything, I'm going to be surprised and I'm going to be saddened. If it does happen, then I would say that this is kind of the perfect area for a really quick update to the Copyright Act.
Just the one-liners, right?
Can you not take a videotape of anybody who has a tattoo now? Can you not put them in film? It's preposterous.
Well,
go home. These guys are just trying to get a buck. There should be some relinquishing of your rights in a artistic piece. If you're putting it on someone's face, and especially someone's famous face, like an athlete who is going to be in every
TV
television broadcast. Does that mean that every NBA broadcast is a copyright violation now? Oh, please.
I know, exactly. You know what I mean, though. The theory, and that's what's happening here, is when you expand theory. Now, I think the best chance we had at getting this question answered actually was the Hangover 2.
Right, the Mike Tyson tattoo, because
that was more significant.
It's gigantic. But at the same, I have the same concerns, to be honest with you.
But it played a huge role in a movie, and it was put on a different character.
Yeah, okay, fair.
You at least avoided some of the de minimis stuff you were just talking about.
That's a fair point. I'll concede that. But at the same time, I think that there is some sort of implicit relinquishing of your rights to a particular piece of art when you put it on a famous person's face.
And you're getting into that point to the territory of implied license. And
yes.
What did the actions of the creator imply that they intended to happen with it on the other side?
Yeah, and I don't think it's a stretch to say that when you put a piece of art on
a famous person's
athlete
body,
or a famous actor's body that you implicitly grant a license to the people who are going to be videotaping that person on a regular basis, as you know, unless, you know, your head is in the sand when you're doing it, that you kind of give up the right to sue the people who are putting in movies.
I'm gonna say this. I don't watch basketball. I'm from New Orleans. Our team's the Pelicans. I don't watch basketball. It's just easier that way on me. But if Kobe Bryant walked into my tattoo studio, I think I would know.
Yeah.
I think I would know.
You would be happy if he did, because your art will be on national television.
He does not want my art on him. I have no artistic talent, but the point remains. What confuses me about it is, like you said, is what did they think was going to happen when they tattooed all these famous basketball players? What outcome did they envision, if not that it would be on TV and video games, et cetera, et cetera, et cetera?
I guess they would argue that, you know, with NBA 2K17 isn't exactly losing any gameplay, you know, viability by leaving out the tattoos.
Right.
Which is understandable. They don't have to have it, although on the same time, I do understand their desire to have avatars that accurately represent the players.
Yeah, and and this exact issue with video games and tattoos came up previously with the UFC games. But as with the Mike Tyson and the Hangover, and as with the other previous cases, they've all been settled before any ruling has come down. Because both sides, I think, kind of wake up and realize this just isn't worth it. We're sitting here, you know what I mean? But here, this tattoo artist claims he offered them a perpetual license for $1.4 million, is it? I mean, just wow.
Wow, indeed.
How do I create something that I can license for that much? You know, just, you know, for a video game only, just a piece of artwork. I'm pretty sure that, you know, that is completely out of line with the going rate for such licenses in a video game of any artwork.
I think it is too.
So to me, it seems crazy. Yeah, 1.14 million. I'm sorry, not 1.4, 1.14. Still, that doesn't help. That's much more reasonable. They knocked off a whole 2.6 million, you know, 0.26 million. No, that's not the point. So I predict this one will probably wind up being a quickly settled one with terms undisclosed, yada, 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 just because there's not enough money to be made on the one side to fight it out, and there's not enough, you know, it's just easier. It's just easier on everyone.
I think it'll get settled as well, but it's a very interesting academic point, and it is the kind of thing that I would expect the law would be like, hey, please don't bother us with this.
Let's not have this exercise again, because, and that's always like and it's weird because when you in copyright law classes, they actually use the tattoo question as a hypothetical all the time. It's one of those perpetual hypotheticals. And it's always like, well, A, is it copyrightable? Well, it's a tangible medium of expression, yada, yada, yada. So that seems to be good. And then can you sue? Well, then you get into the implied license discussion. Then we start, you know, basically realizing that you would be an absolute bonkers idiot to not assume a tattoo on a public part of a famous person would be used. So,
agreed.
And honestly, my suspicion is this. I've always suspected that about these cases, is that the lawsuit is less about getting royalties for the use of the image and more about making sure that you and me and everyone else knows that Solid Oak Sketches LLC tattooed LeBron James and Kobe Bryant.
You're probably right. But then again, it's expensive to file these things.
Yeah, it is expensive. So I don't know. I guess we will see. Well, that's all the copyright news I got. I get us pretty well caught up, and we were able to discuss some of the stories I did not include, but were related enough to loop around to.
We even got an extra one with the Mike Huckabee story.
Yes, we did. Yes, we did. A full extra one. So I'm happy about that. You were right. I should have included it, but it is a very bizarre argument, to put it modestly. But hey, you know, it's the spaghetti system of legal argument. You just throw everything at the wall and see what sticks.
Exactly.
Well, On that note, everyone, my name is Jonathan Bailey. Once again, I am from the website Plagiarism Today, which can be found at plagiarismtoday.com, and I am username Plagiarism Today on Twitter, Facebook, Instagram, Pinterest, all the places. That's where you'll find me.
And you can find me on Twitter at Evan Sherris. Please feel free to reach out. And, send me an email, esharis@gmail.com.
And if you have any other outrageous dares that he should be trying when the monkey selfie case reemerges and the monkey wins, feel free to send those suggestions.
Agreed.
On that note, everyone, thank you very much for joining us, and we will see you guys next episode.